Your company is essential to you. You strive for a market position, want to differentiate yourself from the competition, and generate profit for further growth. That's why you improve your products and services, ensure proper promotion, build sales networks, invest in new technologies or research and development, and hire marketing and accounting specialists. But do you protect your intellectual and industrial property rights in your business? This video serves as an introduction to these issues, particularly if you want to protect your business in Europe and Poland. You need this information to run an effective, modern business. Intellectual property rights affect almost all aspects of a company's organization and operations, relationships with employees, partners, and competitors. In today's knowledge and technology-driven world, understanding these rights will facilitate decision-making, optimize costs, reduce investment risk, and ultimately achieve business success. Intellectual property rights are divided into two main categories: industrial property rights, including patents for inventions, utility models, industrial designs, trademarks, geographical indications, and semiconductor topographies, copyright and related rights. It is worth noting that the broader scope of intellectual property rights also includes the exclusive rights to new plant varieties, the right to a company, and the right to an image. Industrial property rights are obtained through filings or registration with the appropriate institution, such as the Polish Patent Office. Obtaining industrial property rights involves fees that must be paid both at the beginning of the procedure and during the protection period. Both the amount and frequency of payments depend on the type of exclusive right. In contrast, copyright in Poland is not subject to registration and arises automatically by law. Intellectual property rights are exclusive rights, meaning that the authorized persons or entities have a monopoly on deriving benefits from them. They are also territorially and temporally limited, meaning that they can be used only in a specific area and for a specified period. They have a material nature and are transferable, excluding personal copyrights, meaning they can be inherited, sold, or transferred. Several types of rights may apply to one product, protecting its various elements. What intellectual property rights can your business use? Trademarks. Trademarks are among the most popular industrial property rights. We encounter them everywhere, on packaging, everyday items, store signs, and advertisements. Famous trademarks are worth millions of dollars and are recognized worldwide. But is a trademark just a word or image placed on a product? Trademarks play a crucial role in the promotional and commercial activities of any company. A trademark can be any designation that distinguishes the goods or services of one company from the goods or services of other companies. Such a designation must be presented in a way that allows for a clear and accurate determination of the subject of protection in the trademark registers. Trademarks come in various forms. Okay, next. Industrial designs. Industrial designs are used in many industries. They relate to the appearance of products, protect their external form, and allow for the benefits of unique product designs, making them a vital element of trade success. Effectively protected industrial designs are a significant component of an industrial property rights portfolio. An industrial design is a new and individual design of a product or its part, given to it in particular by the features of lines, contours, shapes, colors, structure, or material of the product and its ornamentation. In short, an industrial design determines the external form of an object. Almost any product or handicraft can be protected as an industrial design. This definition applies to a vast number of goods present on the market, or their parts. For example, car models, household appliances, furniture, clothing, toys. Inventions and utility models. Both inventions and utility models are protected, and the exclusive rights granted to them concern technical solutions. An invention is a technical solution whose creation bears the characteristics of a creative act and solves an existing technical problem in a given field of technology. A utility model is often referred to as a small patent. A solution protected as a utility model must have a technical character and relate to the shape, structure, or assembly of a product of durable form, spatially determined products. In addition, the utility model must be new, that is not disclosed in the state-of-the-art, and useful. It must allow achieving a goal that has practical significance in the manufacture or use of products. Integrated circuit topographies are a relatively rare solution today that involves a spatial arrangement expressed in any way of elements, of which at least one is an active element and all or part of the connections of the integrated circuit. Topographies of integrated circuits are protected if they are original, the result of the intellectual work of the creator, and were not widely known at the time of their creation. The right to register integrated circuit topographies is granted without checking during the application proceedings for the existence of all the significant conditions required. Verification of compliance with all conditions necessary to obtain exclusive rights may already occur after the right is granted as a result of opposition by a third party or in a dispute procedure for its invalidation. Geographical indications are used to mark industrial and agricultural products. A geographical indication is a word mark that refers directly or indirectly to the name of the place, region, or country from which a given product originates. The indication contains an element of the name of the region or city. Registration rights are granted to indications for goods that are strongly associated with a particular region or place, and whose high quality and positive opinion are associated with their geographic origin. A single entrepreneur cannot file an application, only an organization or local government administration. Copyright protects works, that is, such products of human creative activity that have an individual character and are fixed in any form. Legal protection is independent of the value, purpose, or manner of expressing the work. Copyright is divided into personal copyright, economic copyright. Personal copyright is inseparably linked to the creator and therefore cannot be transferred to other persons. Examples of personal copyright include the right to authorship of a work, indication as the author, or the right to decide on the first presentation of the work to the public. In turn, economic copyright has an economic character. It includes the exclusive right to use the work and dispose of it in all fields of use, as well as the right to remuneration for the use of the work. As the creator, you can transfer these rights, for a fee or completely for free, to other persons. You can also acquire them in a special way provided for by law. For example, as an employer in relation to works created by your employees as part of their work duties, employee inventions. Copyrights are the most common of the broadly understood intellectual property rights. When running a business, you probably don't realize how many works can be created during your normal activity. Even works that are created unconsciously are protected by copyright. You should know what rights you have and how to protect them. In the next episode, I will explain why it is worth protecting the intellectual property of your business. If you're seeking professional legal assistance for intellectual property protection in Poland and the European Union, I'm here to help. To learn more about how we can assist you in securing your intellectual property rights, I invite you to visit our website at defbrand.eu. There, you can explore our services and discover the ways we can support your goals. Okay? Thanks for watching. Bye.